look at is finality. This is an area that I think is particularly egregious under American law. The United States Supreme Court, two justices of the United States Supreme Court, at least openly, Justice Scalia, the late Justice Scalia, and Justice Thomas, have said that it is not unconstitutional to execute a factually innocent defendant. That all that the Constitution demands and all that the federal courts can do is determine whether the trial of the defendant, the trial or trials of the defendant, were fair and had no constitutional error. A friend of mine, who's a member of the AHLJ, is on the Supreme Court of Missouri. They had a case, and a death penalty case, where there was so significant, the defendant had raised innocence issues, and the Deputy Attorney General arguing the case was asked by one of the justices, should the state be entitled to execute this defendant if we knew, and knew that he was factually innocent? And the answer was yes, because the state is entitled to finality. If there is no constitutional error, the state is entitled to finality. There is no such idea in Jewish law of finality, and one of the attachments that I included is from Mishnah 1 in Sanhedrin chapter 6, and I'll just read it to you. The scene for this is the defendant who has been found guilty of a capital crime is being taken to the place of execution to be executed. When the trial is completed, the condemned is led forth to be stoned. The place of stoning was outside of the court, as it says, bring out him that has cursed. A man was stationed at the door of the court with the handkerchief at his hand, and a man on a horse was stationed at a distance within sight of him. If one says, and this is as they're leading this defendant to the place of execution, if one says, I have something further to state in his favor, he waves the handkerchief and the man on the horse runs and stops them. And even if he, the convict himself, says, I have something to plead in my own favor, he is brought back even 4 or 5 times, providing, however, that there is substance in his assertion. If they then find him innocent, they discharge him. So there is no real notion of finality, in I believe, or I argue, in Jewish law. As someone's being led to the death, to the place of execution, he can say, I've got more evidence. Call off the execution, bring them back. The effort, I think, everything that what permeates Jewish law and on the death penalty and on capital punishment is what you were suggesting, Sam. There's this enormous reluctance to have capital punishment and to use it. And this is illustrated by this lack of finality. Whereas in American law, we have that finality. And we know that innocent people have been executed. Now the courts say, the Supreme Court has said, if someone is factually innocent, the executive branch, namely the governors through their power of clemency, can resolve the issue. Well, we know that governors are politicians, number one. We know that almost all clemencies, when they do occur, happen near the end of the governor's term, just as he or she is leaving office. So that's a very weak instrument to rely on. So I think this idea of lack of finality, that we're always open, that the courts should always be open to more evidence if it's available and not use rigid procedural notions to keep that evidence out and to even say, boldly say, yes, we know he's innocent, but the state is entitled to finality, execute that individual, is egregious in the extreme, and I think we can learn something from Jewish law in that regard.